Judgment of conviction enters as to count 1, reckless manslaughter, and as to counts 3, 4, 5, and 6, the habitual criminal counts. The first thing the court would like to do is acknowledge the pain of the family of the victim in this case and of the friends of the victim in this case, and everybody who has suffered extreme trauma as a result of the defendant's actions back in October of 2012. I cannot fathom the pain. In 25 years of doing this kind of work, I have not seen as much pain in connection with a case as I have seen in this case. The court agrees that a 24-year sentence is not commensurate with the amount of pain and sorrow and suffering that all of the family members and friends and those connected with the case have suffered. At the same time, the court wants to thank the jury for their service in this case. I commend the jury for their service in this case. These were 12 citizens who did not sign up for a 2-week trial. These were people ordered to come to court randomly to sit on a trial, and who all could have said, "This is a first-degree murder case. I know there will be immense trauma in it, and I can't do it." But we had 12 volunteers who agreed to listen to the evidence and weigh the evidence in this case. I don't know this directly, but I can't imagine that at least some of them are not traumatized and continue to be traumatized by the evidence that they heard and saw in this case. The jury ultimately decided that Mr. Hoffendorfer killed Ms. Nichols recklessly. He'd been charged with first-degree murder, which required that he acted with intent to kill Ms. Nichols and had deliberated about it. The lesser of second-degree murder required that the jury be persuaded beyond a reasonable doubt that he knew he was killing her as he killed her. The jury ultimately was persuaded beyond a reasonable doubt that what Mr. Hoffendorfer had done was to engage with the victim in this case and cause her death through his reckless actions. One can infer, and the court does infer, that the 2 primary pieces of evidence in this case that support the verdict of the jury was the strangulation testimony of the ex-wife in this case and the testimony of Dr. Kelly that while a healthy person would revive having been rendered unconscious through strangulation fairly soon after losing consciousness, but that a person who suffered the throes of addiction to heroin and was under the influence of heroin could very well not revive. Those 2 pieces of evidence are, in my mind, what explained the jury's verdict. And again, I commend the jury for the sacrifice that they made to reach a verdict for this community. I'd also note the beyond a reasonable doubt standard that has prevailed in America for hundreds of years. It's the highest standard under the law. The jury obviously had a reasonable doubt about Mr. Hoffendorfer's intent on the evening in question, but coalesced as a group of 12 around the reckless manslaughter conviction that they did. I also want to acknowledge the court's unhappiness with the court for not allowing Mr. Hoffendorfer's other bad acts into evidence at the trial, including the misconduct and criminal behavior that he engaged with his ex-wife. The court, however, is very confident that had I admitted that evidence and had the jury rendered a verdict of second-degree murder or first-degree murder, the Court of Appeals would have sent it right back to say, we don't try people on their past crimes. We try them on the crime before the court. Turning to you, Mr. Hollendorfer, I made several comments last week, some of which I'll repeat here. Uh, you were 36 or 35 on the date of offense. You preyed upon a woman half your age whom you could have been the father to. You knew she was a heroin addict. You knew she wanted heroin. You gave her heroin. You used her body in a vile way. You put your hands around her neck and you rendered her unconscious. Something that, as I recall from your ex wife's testimony, had not happened with her. But you rendered Ms. Nichols unconscious there in your car. You watched her continue to be unconscious as she lay there in your car. And she continued to be unconscious and she wasn't reviving. And yet you still didn't do a thing to call emergency services. You could have easily called 911. You could have driven her to the emergency room. But instead, you sat there next to a fellow human being and you watched her die because of your actions. You then aggravated the situation even more by driving her body to your parents' house, where you must have spent hours upon hours digging a hole in the ground and placing her body in numerous plastic bags, putting her in there, putting dirt on her, putting more dirt on her, putting more on her, which must have, again, taken hours of hiding the evidence of your crime. You thought you would get away with it, and yet you're contacted by law enforcement less than a year later. And as Ms. Peroni pointed out, you had the opportunity right then to explain what you say happened in that car, and yet you didn't. And you had another follow-up opportunity where you didn't. You had to know the immense pain that you caused the family. Nothing worse than seeing a child predecease you. Nothing worse than not knowing where your child is, not just for a couple of hours or days, but for a decade. And so for a decade, you held your secret to yourself while this family and their network of friends and associates suffered and suffered and suffered. The case was broken open when police reached out again to your ex-wife, who then described her conversation with you, which finally, thankfully, too late, led to the discovery of Ms. Nichols' body. She described for the jury how around this time you were in the throes yourself of a methamphetamine addiction and a crack addiction and were using heroin. The jury heard all of that. She described for this jury and who knows how many people watching on live stream the intimate behavior that she engaged in with you, evidence that would normally be prohibited and shielded by the rape shield statute, she described. Finally, she told police and testified to the fact that you, in your own mind, believe you killed your father as a result of this. That you told your father after the police had contacted them that you had killed Kara Nichols. And you told your ex-wife how, in your mind, his death shortly after finding out from you that you had killed this young woman is what killed him. You have seen the pain you have caused. You have seen the agony and the sorrow you have caused. You, one person, because of your conduct on one night, have caused more than a decade of absolute pain, agony, and sorrow. Pain, agony, and sorrow that will not cease ever, ever. The court does find that the 24-year sentence that is required by statute is the appropriate sentence in terms of a proportionality review. As I stated before, it is not commensurate with the absolute pain that you have caused, the absolute destruction you have caused, most important, the loss of a young woman's life. And so the court hereby imposes the 24-year sentence in the Department of Corrections, grants you the 571 days of credit for time served. Is there anything else from the people?
Just the order of restitution, Your Honor. Thank you.
And I've given Mr. Husher another 2 weeks or so to file any kind of objection, and then I'll rule on that if there's an objection. Anything else from defense?
No, Your Honor.
Court will be in recess.
Rise.